Good evening. My name is Austin Ownby, and on behalf of the Washington, D.C. Lawyer Chapter of the American Constitution Society, I would like to invite you to tonight's event, a post-mortem on voter protection from the last election. I would like to first thank the panelists who are all going to be introduced momentarily for agreeing to participate in this event, but I would also like to thank our co-sponsors, the lawyer chapters from Connecticut, the Dallas-Fort Worth area, Madison, Virginia, Austin, and Northeast Ohio chapter. With that, I would like to mention that immediately following this event, we have another event that the Washington, D.C. chapter is co-sponsoring that's being put on by the ACS of Georgia. So you want to work for the new administration, jobs in the executive branch, that begins at 7:30 tonight. So feel free when we're done here tonight to jump over to another, which should be excellent panel. And then I would also like to invite you to a whole series of other events that we have coming up over the course of the next couple of weeks. On Friday, the ACS LA chapter is putting on an event called Righting Wrongs, Truth and Healing for Indigenous Communities Through Law and Policy. Next Monday, ACS DC and ACS LA have joined up to put on a panel on the second impeachment of Donald J. Trump, which should be a very interesting panel the day before oral arguments are set to commence. The very next day, on February 4th, ACS DC is also hosting an event on expanding the judiciary and other responses to the right's unprecedented power grab. And then finally, on February 16th, we are proud to co-sponsor with ACS New York an event called A Basic Income for Families, the Prospect for an American Child Allowance. So as you can see, there's lots of great events coming up. Feel free to jump onto the ACS website to see all of the events coming up and to hear about future events. With that, I will turn it over to Doha Mekki to introduce our panelists.
Thank you, Austin. As he mentioned, my name is Doha Mekki, and I have the distinct pleasure of moderating tonight's program on voter protection and voter suppression efforts during the, shall we say, historic 2020 election cycle. Suffice it to say, there's a lot to discuss. Fortunately for us, we're joined by four truly stellar panelists who will offer their insights on the successes and failures of efforts to expand access to the polls, as well as some important lessons for the future. Our first panelist is Aria Branch. Aria is a partner in the political law group at Perkins Coie in Washington, D.C. She counsels federal and state elected officials, candidates, political parties, PACs, and other organizations on campaign finance and ethics issues. She also litigates political law cases, including voting rights and redistricting cases. She recently represented plaintiffs challenging burdensome voting laws in Virginia and Wisconsin. She was also a part of the teams that successfully briefed and argued two cases on redistricting before the US Supreme Court, Bethune-Hill versus Virginia State Board of Elections and Cooper versus Harris. Aria holds a BA from Duke University and a JD from Harvard Law School. I should also mention that Aria is a deserving person to celebrate this Black History Month. In addition to all of the other things that I just described, Aria was recently featured in Law 360 for her commendable work counseling Ivy PAC, a political action committee dedicated to helping Black women who are sisters of Alpha Kappa Alpha get into politics. So Aria, personally, I would like to thank you for everything you do to make sure our elected officials are as diverse as the country. Our next panelist is a legal eagle and celebrity in her own right. Dahlia Lithwick is a senior editor at Slate, where she has been writing their Supreme Court dispatches and jurisprudence columns since 1999. Her work has appeared in the New York Times, Harper's, The New Yorker, The Washington Post, The New Republic, and Commentary, among other places. She is also host of Amicus, Slate's award-winning biweekly podcast about the law and the Supreme Court. She is currently working on a new book, Lady Justice, for Penguin Press. In 2018, Dahlia received ACS's Progressive Champion Award and the Hillman Prize for Opinion and Analysis. She won a 2013 National Magazine Award for her columns on the Affordable Care Act, and she was inducted into the American Academy of Arts and Sciences in October 2018. Dahlia earned her BA from Yale and her JD from Stanford. Earlier in her career, she clerked for Chief Judge Proctor Hugg of the Ninth Circuit. Kermit Roosevelt is a professor of law at the University of Pennsylvania Law School. He works in a diverse range of fields, focusing on constitutional law and conflict of laws. He has published scholarly books in both fields, including his 2010 book, Conflict of Laws, and his 2006 book, The Myth of Judicial Activism. That book sets out standards by which citizens can determine whether the Supreme Court is abusing its authority to interpret the Constitution. He has published articles in the Virginia Law Review, the Michigan Law Review, and the Columbia Law Review, among others. He is also the author of 2 novels, In the Shadow of the Law, published in 2005, and Allegiance. In 2014, he was selected by the American Law Institute as the reporter for the 3rd restatement of Conflict of Laws. Kim holds a JD from Yale Law School and an AB from Harvard. Earlier in his career, he clerked for the Honorable Stephen F. Williams of the DC Circuit and Supreme Court Justice David Souter. Last, but certainly not least, we have the honor of hosting Paul Smith. Paul is a professor from practice at Georgetown Law and the vice president for litigation and strategy at the Campaign Legal Center, an organization that works to protect and promote American democracy. For several decades, while in private practice at Jenner & Block, he had an active Supreme Court practice. He's argued 21 Supreme Court cases, including a number of significant election law cases. He previously served as a member and chair of the National Board of Directors of ACS. Paul holds a JD from Yale Law School, where he was editor-in-chief of the Yale Law Journal. Earlier in his career, he clerked for Judge James Oakes on the Second Circuit and Supreme Court Justice Lewis Powell. So I told you guys we had a really distinguished panel, and without further ado, we'll turn to the discussion. So first, let me say that the public is increasingly aware of and alert to voter suppression efforts. And there's been a lot of litigation about everything from redistricting to early voting to onerous voter ID laws. Aria and Paul, both of you have a lot of experience litigating these kinds of cases in federal and state courts. Can you give us a brief overview of the legal challenges to voter suppression tactics that were decided this election cycle before Election Day?
Sure. First, I want to thank you, Doha, for inviting me to be on the panel, and thank you to ACS. The premise of the question is exactly right. Prior to this election cycle, Republican legislatures, state legislatures across the country have engaged in tactics that have suppressed the vote. They've typically been aimed at suppressing the votes of racial minorities. And obviously our country has a long history of voter suppression directed at racial minorities. I would say prior to this election cycle, there were 2 events that really kind of spurred legislatures to pass voter suppressive laws. I think those 2 events were, obviously the Shelby County decision and the elimination of Section 5, and then also President Obama's election. The backlash that we saw coming from state legislatures after President Obama was elected was significant. And so, following Shelby County, you saw North Carolina pass basically a suite of voter suppressive laws aimed at restricting early voting, the passage of a voter ID law. There were restrictions on voter registration. And so, you saw those laws being struck down by federal courts. The federal court that struck down the North Carolina laws said that they were aimed at disenfranchising and suppressing the votes of racial minorities with surgical precision. And so we've seen that sort of what happened in North Carolina executed by state legislatures in other states across the country. And I think you really can't kind of underestimate the impact that the removal of Section 5 and the Shelby County decision really had. But we at Perkins, I think following the 2010 election, have been litigating to try to strike down these voter suppressive laws across the country. We've seen state legislatures pass restrictions on polling locations, a systematic closure of polling locations in heavily minority communities, restrictions on out-of-precinct voting. We have a case that is going to be before the United States Supreme Court in March, will be heard out of Arizona, related to restrictions on third-party ballot collection, because a lot of Native communities rely on don't rely on the post office to deliver absentee ballots. They rely on members of their community, and there are restrictions on doing so, actually criminal restrictions in Arizona. A couple of years ago, I worked on a really interesting case in Indiana in the 2018 cycle, where we brought Voting Rights Act and constitutional claims to challenge state legislation that was actually going to close polling locations in one specific county in Indiana. So this was state legislation passed by the state legislature, specifically targeted at closing polling locations only in Lake County, Indiana, which is the home of Gary, Indiana. It is heavily, there are a lot of racial minorities that live in Gary. It's probably like the most diverse area of the state of Indiana. And so this was specifically targeted at closing polling locations in those communities. There was no, effort to do education on the closing of these polling locations, to make people aware of new voting locations. So there's been, and that case actually ended favorably because the state didn't actually put into place the restrictions that they were planning to, I think partially in response to the litigation we brought. But there has been, I think historically and following Shelby County, the election of President Obama, significant voter suppressive laws passed by state legislatures. And I think, the 2020 election was basically that on like steroids. And unfortunately, I think because of the narrative of fraud that was promulgated throughout this cycle, we'll see more state legislatures passing voter suppressive laws in the near future.
Thank you, Aria. That's helpful. Paul, do you have anything else to add?
Several things. If you talk about vote suppression that occurred this year and in the past, there's a lot to say. Let me first of all just say thanks to ACS and to you, Doha, for organizing this, and also note that this idea that our system is rife with voter fraud, it goes back all the way to the 1990s and was manufactured deliberately by those who were seeking a way to justify vote suppression, whether it was voter ID laws or purges of people for not voting frequently enough. This is this belief that now is prevalent among many Republican voters that the election was stolen is a product of a long disinformation campaign. And that campaign, of course, occurred throughout 2020 in a weirdly different context as we were dealing with the pandemic. Suddenly voting by mail became extremely important. And we had a systematic campaign by the president to persuade his voters that voting by mail is inherently fraudulent. And so that by itself discouraged a lot of people from voting who didn't want to come down and vote in person and were told by the president that voting by mail is such a terrible thing they shouldn't do it. And the Secretary of State in Georgia said that's really what cost Trump the election was that some of his own voters who voted in the primary didn't vote in the general because of his attack on voting by mail. But there was a lot of other stuff about voting by mail that was fought out ferociously as we went through the year. One of the things that had been a feature of voting by mail for years, but became suddenly important when we have half the people voting that way in some states was this idea of signature matching to throw votes out, which is, the advocates didn't really try to attack it, but one of the goals we tried to pursue this year was at least you ought to find out and have an opportunity to cure if your vote's being thrown out based on a perception that the signature on file doesn't match the signature on your ballot. It also, we can't fail to mention that the president and his people mounted a remarkably aggressive assault on the post office, trying to prevent it from being able to get the ballots delivered on time. And so really remarkable. You could mention a lot of other specific things. In Texas, the governor ordering out of the blue that only one drop box can exist in each county, whether it's a county of 10 million or 10,000. We had the whole saga of ex-felons, formerly incarcerated people in Florida, 750,000 who were prevented from registering to vote because they couldn't pay fines and fees, an issue that we litigated up to the 11th Circuit. There was a ton of stuff going on this year But the overall narrative was some people wanted fewer people voting and some people wanted more people voting. And much of that was fought out in new and distinctive ways because of the pandemic. But it's an old story that we've been living now for 25 years or more.
That's really interesting. You predicted my next question, which is, we heard a lot about voting by mail before Election Day, and I'm curious to know, was voting by mail actually challenged before the November election?
I'm not remembering, maybe Aria can correct me because she has a more encyclopedic knowledge of every case that was litigated. Anybody saying that there shouldn't be voting by mail before the election. There was a big fight in Texas about their rule that you had to be over 65 to have free access to voting by mail, a rule that by its very nature favored more conservative, more Anglo people. That went up to the Supreme Court and they were able to keep that rule. After the election, of course, there was an attack on voting by mail. The claim was that all of the votes by mail in Pennsylvania should be thrown out because the Republican legislature never should have authorized voting by mail in the first place. But maybe I'll toss it to Aria. Were there other places where people tried to prevent voting by mail altogether before the election?
I don't think so. I really think that most of the litigation pre-election was about expanding vote by mail. My firm, I think we brought litigation in at least like more than 10 states to try to make it easier for people to vote by mail. And so this included challenging the signature match restrictions that Paul talked about earlier. This idea that your signature has to, on your absentee ballot, has to perfectly match your signature on file with the state from when you filled out your voter registration application. And that if it doesn't match, your ballot would be thrown out without an opportunity to cure. We brought litigation to try to force states to provide prepaid postage to voters so that they could easily or more easily mail back their ballots. A big issue that came up both pre and post-election was the push to have states accept ballots that were postmarked by Election Day, but received after Election Day. And as Paul discussed, the post office was a huge issue. The post office was overwhelmed with mail. It was underfunded, and there were real significant delays such that, a voter could vote, well in advance of Election Day and their ballot not be received by their county prior to Election Day to no fault of the voter. So we brought a lot of litigation around that. And then the final thing was we brought litigation around allowing third parties to deliver voted absentee ballots to counties to kind of get around the post office delays. And so I think there was significant litigation to try to expand vote by mail to make it easier for people to vote by mail. And, there was from the conservative movement, a push against that and backlash for that. One of the restrictions that came up specifically related to the pandemic was the witness requirements. I know this was a big deal in South Carolina, that voters who vote absentee needed to have their ballot signed by a witness, and that was an anti-fraud provision. And so we brought litigation to have that struck down. That eventually, I think that requirement stayed in place, but there was a lot of changes to witness requirements. Obviously, in the middle of a pandemic, people who live alone, don't have family, having someone come into your house or be close to someone to have them witness an absentee ballot, we thought was a real burden on the right to vote. So I think there were lots of changes to the rules around absentee ballots and absentee voting, very close until we got up to the election. And then, following the election, there were challenges on rules that were in place prior to the election. So
that's really helpful. Both you, Aria, and Paul alluded to another topic that I think a lot of us are interested in. Relatively speaking, of course, it seems Election Day maybe went off without a ton of fireworks, again, relatively speaking. But of course, we know that after the polls closed, scores of lawsuits were filed, ostensibly to throw out or otherwise delegitimize votes in several states. Paul, you talked about fraud claims. And so in those cases that were filed after Election Day, what kinds of claims were litigated, and did the claims actually sound in fraud?
This is a really important thing, which I think there's a lot of misunderstanding about. Almost none of the cases, and there were whatever it was, 5 or 6 dozen cases filed after the election by Trump and his allies to try to throw out the election, had anything to do with fraud. The main thing that they were fighting about was claims after the election that election officials in various swing states had been too easy on people voting, had done various things to allow votes to be cast that they shouldn't have done. So in Wisconsin, they allowed people to drop off their ballots or to mail in their ballots without putting a photograph of their voter ID, of their ID in the envelope, or things of that sort. And the claim over and over again was these were violations of state law by the state election officials. And because they were inconsistent with what the state legislature had mandated, they were also violations of the federal constitution, on the theory that the legislature is supposed to set all the rules of presidential elections. And they tried to make a federal case out of all these technical violations. And what they were essentially trying to do was throw out the votes of real voters who had voted in reliance on the rules that were in effect, the systems that were in effect in the states where they lived. And so far from being about fraud, they were about invalidating real votes that were undoubtedly cast by real voters on the most technical grounds, litigating issues after the fact that courts kept saying, you can't litigate that issue after the fact. We're not going to throw out 10,000, 100,000 votes because you think they should have had to put an extra piece of paper in the envelope or they failed to sign this document. These kinds of hyper-technical violations of state statutes or state regs that were often done just to make it possible for people to vote more easily, but didn't raise any question at all of fraud or concern that there was any inaccuracy in the tally. They were simply trying to win the election by getting real people's votes thrown out after the fact through these technical arguments. Almost all the cases. There are a couple of cases where they alleged fraud, and those fraud claims were by and large debunked almost instantaneously, but most of the time they were not willing to make fraud claims because they didn't have any evidence of fraud claims.
Yeah, I think that's exactly right. And something interesting I thought about was in a lot of the litigation that followed the election, the cases were filed after recounts had already taken place in many of the states. So there have been recounts and then recounts of recounts in Georgia and Wisconsin and in different states where, you know, there clearly was no real change in the vote tally. If there had been this type of widespread fraud that was alleged in the media, but not really alleged in court, or at least no evidence was provided for in court, you know, you would have expected to see wild swings in the recounts, and that just didn't happen. So no matter, you know, how many recounts were done, I think there were 3 in Georgia. In Wisconsin, you saw targeted recounts, so there was not a recount requested of the whole state, but just in Madison and Milwaukee, which, you know, unsurprisingly, those are areas that have higher minority populations. You know, you just didn't see changes in the vote tally, and so it's interesting that a lot of the litigation kind of followed those recounts. You know, there were certainly allegations of fraud, but very little evidence provided of it. Courts threw out the claims of fraud basically unanimously. But there were a lot of cases that were dismissed on procedural grounds. So before you even got to the merits, like there was no merit to the fraud allegations, but, you know, there were defenses of latches because, as Paul said, the plaintiffs were often challenging state election laws that had been in place either for decades or at least long enough prior to the elections that they could have been challenged pre-election. But there was this effort to wait until after the election, see how the results went, and then literally file lawsuits to disenfranchise voters. There were mootness, dismissals on mootness grounds because a lot of the cases were filed, and the relief that was requested was that the election not be certified. And in many of the cases that were filed, the election had already been certified by state officials. So how do you undo a certification? And court said no, like we're not going to do that. Lots of cases were dismissed on standing grounds, and I thought it was interesting that the doctrine of standing became very, very important sort of in the media. This idea that only certain plaintiffs have standing to bring a case. And that has been, I think, a fixture in voting rights cases since the beginning of time. Often in much of the litigation we do and we brief, we spend a significant amount of time on standing. But you saw, President Trump tweeting about standing being, just a mere technicality, and basically kind of alluding that it was sort of a new thing that courts were deciding, and that clearly was not the case. So lots of dismissals on procedural grounds. I think there were over 60 cases that were brought, and the Trump campaign lost all of them. So it was.
Let me just add one other thing. One of the most remarkable things of the whole post-election series of events was this case brought by the Attorney General of Texas directly in the Supreme Court, suing the other states, the other swing states, and asking the United States Supreme Court to rule on all these technical issues of state law in other states. And you talk about a standing problem. The idea that Texas and its voters was injured by the other states, the way they administered their elections and the results that they produced, was preposterous. But it really, it certainly got a lot of attention for a couple of days before that we were all confident that the Supreme Court was going to make sure to get rid of it. It was something else.
It's a fascinating point. I think it raises questions, or at least animates in my mind, questions about our constitutional structure, right? Like one state suing over the procedures of another state, and the notion that, Texas could be injured by the procedures of Pennsylvania or Georgia or whatever state it was. And so I want to pivot to talking a little bit about constitutional structure. So one of the most fascinating things to me about the election was that despite record high voter registration and turnout in 2020, the realities of the Electoral College were such that the distribution of votes across a number of states would invariably have an important impact on the election outcome. So Kim, I want to turn to you. What does this suggest about our constitutional structure? And specifically, do you worry at all about the ways that political minorities can control the federal government?
Yeah, I do. I absolutely do. And that's something that really became apparent to me. I think other people probably perceived this earlier, but it really became apparent to me this election cycle. So we all know about the Electoral College and how it works, and the fact that the person who gets fewer votes can still end up being elected president. And then, maybe we've made our peace with that, or maybe we want to change the Electoral College. I personally do. But I think that a lot of people don't appreciate the extent to which this affects the other branches of the federal government too. So in the Senate, of course, you've got equal representation, 2 senators per state. And that means that senators representing a minority of the population can very easily control the Senate, because Wyoming has as many senators as California, and the Dakotas count as much as Florida and New York together. So in the Senate, a minority can easily control. In the House of Representatives, with the partisan gerrymander, if you draw your congressional districts right within a state, you can get fewer votes in that state's congressional election and still elect a majority of the state's representatives. And then when it comes to the judiciary, you can have your minority vote getting president nominating judges who are then confirmed by senators representing a minority of the population. And it almost sounds like I'm spinning this fancy scenario about what could possibly happen under our Constitution. And maybe you would think it could never happen. And these features of the system wouldn't matter so much if we didn't have a 2-party system. And they wouldn't matter so much if we didn't have a distribution of voters so that the features that I've just described reliably favor one party, but they do, because generally speaking, these work to empower low population states. And those tend to be rural states, and the rural populations tend to be white, and the white rural populations tend to vote Republican. So we're actually very close to a situation in which the Republican Party gets fewer votes in every election nationwide, but can still control all three branches of the federal government. And that, I think, is alarming from a Democratic perspective. First, because I generally think the person who gets the most votes should win. But second, if your strategy for holding on to power is making sure that your minority of voters are in the right places to win, I think that gives you a very negative attitude towards democracy generally. I think that makes you lean toward voter suppression as a strategy.
It's an interesting question. I mean, do you then view democracy as a means or an end? And I'll also throw in one more question, which is, do you think, Kim, that the Constitution contemplates these kinds of frictions?
Well, see, I don't think that the Constitution was designed to do this. If you talk to people about the Electoral College, some people will tell you this is the genius of our founders, and they wanted to make sure that the cities didn't dominate or the coasts didn't dominate. Turns out it's not the case that the cities or the coasts would dominate. If we got rid of the Electoral College, what would happen actually is that attention would spread out from the small number of swing states that people currently focus obsessively on. So I don't think this is part of the constitutional design. You know, the framers didn't anticipate the party system. They certainly didn't anticipate that you would have a party that was backed by the rural population against the cities in the way that we sort of do now. But what you said about democracy as a means to an end, I think is very interesting, because I tend to be a fan of democracy, but I'm not so sure that our Constitution is. And the Declaration of Independence, actually, I think isn't either. This is part of something that a bigger project that I'm working on. But I think, interestingly, if you look at the Declaration of Independence, it doesn't say much about democracy. It says the point of government is to protect individuals' natural rights. And if your government is doing that, it's legitimate. And it doesn't really matter what its form is. You know, the colonists were, of course, rebelling against the monarchy, but they didn't say King George is illegitimate because he's a king. They went on to argue that he was, in fact, a tyrant, that he was depriving them of their natural rights. So I don't think that founding America has much of a commitment to democracy. It's there more in the Constitution than it is in the Declaration. But when do we get a real democratic vision? I think it's the Gettysburg Address, because Lincoln is talking about government of the people, by the people, for the people. That's democracy. The Reconstruction Amendments, the 14th Amendment, the 15th Amendment, more obviously, that's democracy. So I think the idea that democracy is a value in and of itself is sort of a latecomer to our Constitution. And I think it comes with Reconstruction.
So I will open this up to all of the panelists. You know, in view of those concerns, do you think that some of the issues created by the Electoral College can be addressed at the federal level, or is this a state-by-state sort of problem that needs to be addressed?
I might just make one side note, if I could, sort of following on something that Aria said that I think is really important, which is the whole point here is to foment mistrust in certain voters, right? And that's been, you know, as Paul says, that's been the mission of the vote fraud crusade for a very long time, that a certain class of voters can't be trusted to vote reliably. And I think that the move that has happened that's really recent, in addition to what Kim just said about, you know, we now have minority majority Senate ratifying minority majority presidents, pick of minority majority Supreme Court. I mean, we've got an entire minority majority ecosystem now. But I think the move that's new and really alarming that I think we have to reckon with is the claim that it's not just that some voters can't be trusted, but that certain people can't be trusted to govern. That's what's new. And I think that undergirding this whole including, I think, the sort of laugh out loud Texas suit, but undergirding so much of the rhetoric. And what I think is new is not just a challenge to voting as something that should be accessible to everyone, but also governance as something that should be accessible to everyone. And I think that is a really alarming turn that has been very, very amply played out in the last few months, including in some sense, fighting the certification and fighting the ratification of the electoral votes. And I think that's overt rhetoric that is slightly distinct, but actually follows from claims about who can and can't vote.
Let me jump in, Doha, on the Electoral College. We've all worried for years about the fact that it elects presidents who don't get a majority of the vote, and that is what has produced the Supreme Court we have now. 5 of the 6 justices were appointed by Bush or Trump, who didn't win the majority of the popular vote. And that's a major problem very difficult to solve, but a problem. There are people making efforts to do it with the popular vote compact and all. But what we learned distinctively this year, in addition, and this is caught up with what Dahlia was talking about, is this notion that the system of the Electoral College, this process you go through where you have people picked and then they meet in December and then they mail the votes off and the Congress meets and they have objections in January. That whole system is full of terrible vulnerabilities if people are willing to take the view that there's only one lawful winner. We know who it is before the election even happens. And we actually came pretty darn close this year to having several state legislatures vote to send their own electoral votes to Washington to try to overturn the popular votes in their states. A large number of legislators endorsed that idea in several of the swing states. And then we had a very large number of members of Congress who actually voted not to let the winner win. It didn't happen this time for a variety of reasons. That the election wasn't very close, and we have a majority of people in both House and Senate who weren't going to be that anti-democratic, a whole variety of things. But it is really terrifying if you have one side of the political aisle that's willing to do anything to win because they don't believe in democracy, they believe in winning and power. And they are willing to use these levers that are just sitting there. And they have been sitting there all these years, but nobody's really focused on them before. And so one of the things that needs to happen is we need to fix, to the extent we can, the statute that governs all this process, the Electoral Count Act. And there are going to be proposals we're developing to say that we have to rein in what Congress happened there. We have to rein in these legislative vetoes after the fact. These things can be dealt with some degree of effectiveness through statutory amendments of that strange old act that was passed in 1887.
So I also want to ask the group, in view of what's happened this election cycle, do you think it laid the groundwork for interesting future suppression issues, or did it reveal the need for other additional specific voter protections in the future? Paul, you named a couple, but I've heard a little bit about HR 1 and other proposed resolutions to try to avoid similar issues in the future.
We're at an interesting moment here because in a number of the states out there, there are very aggressive moves being made to take back the ability to vote by mail, to take back early voting, to add additional burdens, requiring people to mail in IDs with their votes, and a whole variety of things to try to reduce voting, because people were alarmed at how many people voted despite all the barriers to voting that were in place this year. And the reason that this situation is interesting, and there's nothing new about any of those kinds of efforts, is that we really can't rely on the federal courts with the way that the courts have been packed by Mr. Trump and all. And so what does that leave? That leaves Congress, and it leaves HR 1. And we have this moment where Congress can, if it is willing to do it, step up and actually put in place a wide variety of things that are in HR 1 that would fix the purging, the IDs, the registration problems, require early voting, a whole series of things that can make the democracy work better and will be difficult for a conservative judiciary, I think, to dismantle. But if Congress doesn't act and we simply let states do this stuff and try to go to court and sue under the Constitution, that hasn't been working very well for quite a number of years, and it's going to get worse, I think. So Congress needs to find some time this year to pass HR 1. And if they do, along with HR 4, the restoration of the pre-clearance regime that was taken out in Shelby County, we could really have a major set of improvements in our democracy.
And maybe I would just say explicitly, Doha, what Paul said kind of implicitly at the beginning, which is, I think it's really alluring to say that the story of this election is that the system's held and everything worked. And, you know, it was a huge spike the football moment for democracy in electoral systems. And the truth is, like, but for the Krakenness of the Kraken, it would have ended differently. And I think not only does that mean, as Paul says, that we need to be really mindful that the same people in Georgia who refused to flip the election for Trump are now doubling down on voter suppression measures going forward. And we're feting them as heroes of democracy. And so I think maybe the sort of footprint to look at isn't the footprint of what happened in some sense, but what could have happened. And I think you kind of need to look no further than just Supreme Court dicta being thrown out before the election, where, you know, Brett Kavanaugh is pushing crackpot, you know, Rehnquist minority theories from Bush v. Gore, and Sam Alito is saying that voting by mail casts a shadow of doubt, and he gets people to sign on with that kind of dicta. So I think it's very easy to say that the Supreme Court stood back and didn't do anything catastrophic, but I think that the goalposts moved in a lot of ways, even if it's simply Supreme Court justices signaling a readiness to move the goalposts if a proper, you know, properly briefed and argued suit comes along. And so I think we have to be so mindful of kind of not patting ourselves on the back for all the ways in which systems work, because systems worked in some sense only because of the terribleness of the suits that Aria is describing. They didn't work because there is not a superstructure in place that would very much like to bless a lot of the moves we've seen coming for decades.
I think that's exactly spot on. And I think, you know, the post-election period was a really kind of frightening time for democracy. I think for all of us who are concerned about democracy. I mean, I think the courts held this time, but we don't know what would happen the next time around. And the groundwork has been laid. The narrative of fraud has been laid for, you know, things to go wrong next time. So I do think there's a real need for democracy reform, and really for a new, you know, narrative. I think we need to, you know, there are lots of really good ideas out there, including HR 1. But we should not forget, you know, what happened this election cycle. The fact that 126 Republican members of Congress were willing to sign on to Texas's brief to the Supreme Court is frightening. And so I think we really, really need to strengthen the system so that the next time around, we're not relying solely on the federal courts and the state courts, which, as Paul said, have been historically unreliable. If the litigation had been, you know, if the Trump campaign had been represented by other lawyers and the litigation had been stronger, you know, we don't know what the outcome may have been. So it's a frightening thing that I think we have the opportunity to reform, and we should do so quickly.
The other thing we were lucky about is key people at key moments, like that guy in Michigan who refused to vote to decertify the election, and whatever we say about Secretary of State in Georgia and what he's doing now to suppress voting, he stood fast against the pressure to throw out the election. But we don't know that those people will be the ones in place next time. They may have less courageous, less principled people in those positions.
What's fascinating about what we just discussed is that there's an ability to bifurcate the what ifs and the hypotheticals, right? On one hand, there's what happens if, those who favor voter suppressive tactics or efforts to delegitimize votes are maybe better represented and bring smarter claims in an election with smaller margins. And then on the other hand, there's the legislative branch, right? There's Congress. And, even if all of the cases turn out the exact same way, there's this question in my mind of what happens if you don't have a democratically composed majority of the House of Representatives, right? I mean, what happens then? I don't know if any of you have thought about specific reforms in Congress that maybe would prevent bad outcomes and the nightmare situations that we've just described or alluded to rather. But if you have ideas, I think it'd be helpful for our audience to hear them.
Well, an amendment to the Electoral Count Act could say that in almost no circumstance is Congress supposed to do anything other than take the votes that were sent in by the state and count them. That their role, to the extent that there is any role, is ministerial, unless there are two sets of votes that have been sent in by two different purported government representatives from the same state. That's the issue that allowed this whole structure of the counting of the votes to be and the objections to be created way back in 1876 when that happened. But that didn't happen this time. Nobody sent votes in except the governors of the states or the secretaries of state, and there was nothing for them to do. There was nothing. They are not a super elections board trying to ferret out fraud and do their own investigations and audits in the January period. And I think we could amend the statute to make that very clear, and that would help in the future. I mean, obviously, you never can completely guarantee what people in Congress are going to do, but that would be a help, I think.
So Dahlia, I want to turn to you and kind of revisit a topic that you discussed earlier. So you've written and spoken very thoughtfully about deflated public confidence in our electoral process and institutions, particularly institutions that were tasked with overseeing the electoral process, like state boards of elections and state secretaries and so forth. But they seem to have suffered a lot in the face of efforts to delegitimize them. Aren't these really forms of voter suppression? And I'm, as a journalist, I'm also curious to know your thoughts, as you watched all of this happen. I mean, what do you think the role of the press or the media was in reporting on the 2020 election cycle?
I mean, it's a great question. And I'm old enough to be able to assert that it always seemed to me every time we had a presidential election roll around that the October before the election was too late for journalists to start to think about, this is kind of a rickety system. We should think about its vulnerabilities. And yet journalism, you could set your clock by it. October 1st, before a presidential election, would start to really think, there could be real problems here, even after Bush v. Gore. And then we did this funny thing at Slate where, Rick Hassan and I, a year before the election, did this election meltdown series where we tried really hard to do this big 5-part series on elections. And some of the listener feedback on the podcast was really fascinatingly circular, which is you're pushing out a lot of worries and concerns about elections, and all you're doing is depressing confidence in election. Like, don't say this because it's going to make people not want to vote or think that their vote doesn't count or is going to be stolen. And it was this kind of weird ontological question as a journalist of, are we not supposed to be surfacing our worries because we want to be cheerleading, like, hey, your vote counts, get out there and do what it takes. And so it really raised this question for me of how do you report about the vulnerabilities without being kind of a part of the problem, which is depressing confidence in the vote. And COVID, I think, exponentially added to that, where an awful lot of people were like, well, if the whole thing is stolen anyway, I'm not going to go risk my life and go vote. So I think it is this very profound sort of journalistic problem where we have to surface the vulnerabilities, and then at the same time I think we have to just keep pointing to solutions. Now I think we dodged a bullet this year for all the reasons that Paul and Aria have talked about, which is the system held, and we were able to say, like, there was no, attempt by foreign entities to cut all the power to Michigan the night before the election, right? That was one of the nightmare scenarios we talked about. None of those things manifested, but I do think it raises a question about, I think this is your question, how do you talk about how rickety and vulnerable the system really is, and how subject to 1,000 kinds of human error and manipulation without being kind of a part of the act of suppressing voter confidence. And I think the flip of it is exactly where Paul started, which is there has been a decades-long concerted effort by some people to do exactly that, to say every election is stolen, and they're busing in foreigners from like Mexico and from Canada to vote 7 times, and they vote as Mickey Mouse. All these dead people are voting, and that's now in the ether. I mean, that really is, in a tragic way, one of the legacies of this election, is that there are millions and millions of people who really believe that. And so I think journalism has this very fine line where it has to both talk about the problems and the vulnerabilities, and also absolutely emphatically say, you don't have the choice to say, therefore it's useless, I'm out. You have to, despite all that, work to pass legislation that cures these things. And at the same time, you have to really help people understand this is not the kind of thing we all can hit the snooze button and like think about again in 4 years.
Of course, that is a huge dilemma. On the other hand, I think it's important to be Pollyannish for a minute, to remember that the American people did vote in record numbers. The Republican voters were dissuaded from voting by mail, but they found other ways to vote early or in person on election day in record numbers. And the other thing that's really was inspiring this year was the huge number of people who chose to be election workers in the polls, even at a time of great personal risk, to stay there and get people voting, to count the votes, even when there were people banging on the doors outside claiming fraud and things. It was a huge collective effort on the part of a lot of anonymous people, voters and officials, that was in some ways a vote of faith in the system as well. Obviously, in a year when a lot of people on both sides cared about the outcome, that helped a great deal as well. But I think we have to remember that it's not that broken that we can't, if we can put in some reforms and tone down the rhetoric, continue to operate with enough faith in the system that people will participate.
That's an important point, Paul. Are there other things that worked well in terms of efforts to expand access to the polls this election cycle?
Well, early voting was a hugely expanded, and I think people really liked it. Being able to vote when there were only 2 or 3 people in line, even if it's 2 or 3. Some people don't like it because you don't have, the election campaign isn't over yet, and you don't have all the information you're going to have on election day. But I think that's here to stay. And voting by mail is a continually growing phenomenon as well. We already had a few states where that's all they have. And I think that phenomenon is going to continue to grow too, although there is going to be this pushback in the short term in some states. Overall, the expansion of voting, despite all the amount of work that lawyers put into fighting about the details of it, really people found ways to vote. And that's a good thing.
I also think there are a number of really extraordinary organizations that are doing, real important work on the ground, registering voters, turning voters out. I think we saw this most notably in Georgia, both, for the November election, but then also in the runoff. There are a lot of organizations that have really, really worked hard to engage voters, to register new voters and to get people to the polls and to understand how important elections are and how much impact they have on people's lives. And I think seeing the successes of their work at the polls has been really heartening. And I think, unfortunately, there's pushback on that as well. In Georgia, you saw prior to the runoff, I think the Secretary of State held a press conference where he basically announced that an investigation into a number of voter mobilization organizations in Georgia. And I think, it's sad because it's really, targeted investigations to try to really tamp down the work and the effectiveness of these organizations, to essentially intimidate them so that they can't exercise their First Amendment rights. And so unfortunately, when there are these great successes, there's, a pushback, and it's almost immediate. And so I think we'll see that going into future elections as well.
I might add that one of the great fears we had going into the election was that there were going to be a lot of voter intimidation by, far right groups that were threatening to, scare people away from voting. It turned out there wasn't very much of that, but what there was very well dealt with through the efforts of election workers, and also through the network that people like the Lawyers Committee organized to get information circulated and get measures taken to protect the polls. And so a ton of people worked in that area as well on election day to try to make sure that there wouldn't be any major disruption. It turned out the disruption occurred in January rather than in November. But we have to remember that November was important.
These are all great points. I have about 1,000,001 other questions for this group, but I want to make sure that there's time for the audience to ask questions. And so if you're watching, please use the Q&A box to pose questions for our panel. It looks like we have a few. So someone asked, what is to be done about the Federal Election Commission, which was essentially inert for the entire Trump presidency?
Well, that's, again, something that's in HR 1 as a fix of how that works. It was designed to be a kind of dysfunctional agency with even numbers of people from the two parties, and a requirement that you get some support from commissioners on both sides. And then, of course, they didn't even staff it. They didn't have enough nominees to even have a quorum for much of the past few years. So it really has been beyond belief dysfunctional. We haven't talked about campaign finance, but the reason we have such run amok abuse of the campaign finance laws is because nobody enforces them. I mean, Campaign Legal Center, we spent an awful lot of time suing the commission to try to get them to enforce it, but the law is set up in such a way that it's very difficult. And so you see these super PACs that are essentially arms of presidential candidates' campaigns that are supposed to be totally independent, but they don't even pretend anymore. And this is a major defect of the system. You can now give unlimited amounts of money to the candidate's super PAC. So, at that point, all bets are off in terms of buying influence and the like. So Federal Election Commission needs a completely different structure in order to become functional. There's no reason we can't do it. We just have to do it.
Another question we received is, for anyone, what do you anticipate will be the major issues in the coming redistricting cycle?
I think that the role of state courts will be an interesting issue. Obviously, last redistricting cycle, we got to the point where it is now, I think, clear that the doors to the federal courthouses are closed for litigation of partisan gerrymandering claims. But there are still states that have pretty liberal state constitutional provisions, including Pennsylvania and North Carolina, and some other states where you can bring a cause of action to challenge partisan gerrymandering under state constitutions and state courts. So I think the role that state courts will play in redistricting litigation will grow this cycle. I also think, a lot of states this cycle have independent redistricting commissions. And so the role that those commissions will play, as opposed to states that still have legislatures draw their maps, will be something else to watch. But I think, the typical claims in redistricting, partisan gerrymandering, racial gerrymandering, and claims under the Voting Rights Act will still be prominent. But there are provisions also, sorry, Paul, in HR 1 that address redistricting,
Right.
and I think push for commissions in all states. So, if HR 1 were to pass, then, we would have some redistricting reform as well.
And it also has criteria that even when the legislature does the line drawing, they have to be fair if it passes. One of the issues you're going to see probably get revived is the issue that was litigated in the Supreme Court about 5 years ago, which is, can a state use independent commissions to draw congressional district lines? The Arizona legislature sued the Arizona Commission in the last round, saying the people who adopted this commission violated the federal constitution. The Constitution says the legislature shall set the times, places, and manners of federal elections, and the commission and the people who voted for it are not the legislature. That claim lost in the Supreme Court 5-4, but the majority of 5 included Justices Ginsburg and Kennedy. And we know they've been replaced by justices likely to be more friendly to the fore. And so there's a real danger out there that even as we move toward greater use of commissions and Congress moves to mandate commissions, that we could see, at least in those states where the commission has been created by popular vote, as in Arizona, an effort to shut them down as to congressional districts. They could still do state legislative districts, and Congress can still mandate this, I think, if they want to. But this issue will arise again, because there will be some state, whether it's Michigan or Arizona or California, where people don't like the congressional districts that were drawn by the commission, and will try to go back to the Supreme Court and see whether they will overrule that Arizona case.
Another interesting audience question that we got is the following. Many of the post-election cases were resolved on standing or laches grounds. Looking to the future, are any of you concerned that this case law may backfire to challenge voter suppression laws in the future? Maybe this group is smarter or better in the courtroom. I don't know.
Yeah, well, so I mean, I would say things like, one of the things that I thought was really interesting about this round of litigation was that usually, and I don't have a huge amount of experience with election litigation, so maybe people have a different perspective on this, but usually when I think of voter suppression and litigation, I think of the state enacting voter suppression measures and then people litigating to try to expand access to the ballot box. And what we saw this time was really voter suppression by litigation after the election, which was unusual. But I don't think that these were unusual doctrines. I don't think these were expansions of doctrines. So to a certain extent, this is the playing field and you play on it. And I don't think that it's tilting that much. The other thing I would say is, standing doctrine is notoriously malleable. So I don't think that anything that happens in one round of cases is necessarily going to lock courts into doing something that they don't want to do in the next round of cases. And then the last thing I would say is a lot of these decisions seemed really quite reasonable to me. So, the idea that you can't have bipartisan support for vote by mail, say nothing about it for a couple of years, run the election, find out that you lose, and then decide to challenge it. If that comes back to hurt my cause, I would still have to say that's a fair rule. You shouldn't get 2 bites at the apple.
Yeah, it doesn't seem likely that the opponents of vote suppression are going to find themselves subject to laches problems. One of the things you try to do if you're trying to attack vote suppression is attack it as early as you can in order that the people get to vote. Because if they haven't voted, there's no fix after the fact. You can't come into court and say, well, if there hadn't been this ID requirement or this purge or something, we would have gotten an extra 150,000 votes for our side. That doesn't work. And so, this was, I think in that aspect of it, a unique a feature of efforts to take the election back and to try to undo votes after the fact, which fortunately was roundly rejected by court after court, saying we're not in the business of disqualifying voters based on technicalities.
Another question we received, actually, there are a few questions that kind of touch on this similar topic, which is, do any of you think that the more frivolous, that's my word, I'm editorializing, the more frivolous lawsuits that were filed after Election Day might disabuse people in the future from using litigation to delegitimize votes?
Dahlia, you predict the future. You know what's coming, right? You can tell us.
I don't predict the future. I don't know if people read that amazing Axios TikTok that came out this morning. I will put it in the chat if people haven't read it, but it's this unbelievable meeting that happened in the White House that took 5 hours, and there was screaming and threats. And I guess the president ambled off and had a meal in the midst of it while everybody was screaming. One of the things that was super interesting in that was that somehow in the 11th hour, I think Sidney Powell was claiming all of the fraud actually was foreign interference. Like she was suddenly all in on the, Chavez, Dominion, China, like there was actually no fraud that was domestic, and it wasn't the Democrats that were perpetrating the fraud. And I just thought, Paul's laughing because it's nuts, but I also think it's sort of like if you lose 60 lawsuits because you can't, as Aria said, adduce any evidence of fraud, and then you lose again and again and again, you can always just say it's Dominion and Chavez. Now I know she's being sued, so maybe this goes away, but my sense is, I'm always the sort of skunk in the elevator. I think that probably the folks who have no shame will not be deterred at all. And that's fairly evident from this, the last couple of weeks. I do think, and this goes to Kim's really good observation, that by and large, the federal courts acquitted themselves across the boards really, really well in this cycle. And I think to the extent that there's going to be any enduring lesson, it's like, I'm sorry, don't bring the crack in. Like you're going to have to do better than what was done. And so I don't know that anyone is going to feel emboldened to be even sillier. But I do think much sillier people are out there.
Yeah, although I think the lesson they'll learn probably is that it's too late after the election to try to undo the election by litigation. And they'll look for ways to keep people from voting beforehand, whether they're laws or whether they're intimidation or purging people from the rolls so they show up and they can't vote. There are methods that will be used, but this will reinforce, I think, the original notion a lot of people had is that the way to maintain power is to keep people from the polling places in the first place. Doing it later on doesn't work because the courts are not interested in taking votes off the table.
I do think we'll see an increase just in litigation overall. And there was obviously a ton of litigation related to the November election, but then you saw a surge of election related to the December runoff. And I've not seen that much litigation related to, one specific election in a long time. Obviously, that was a crucial election to determine control of the Senate, but I think it signals that elections will continue to be litigated, and people will turn to the courts even up to the 11th hour to make it more difficult for people to vote. And that's the opposition that we're facing.
Well, and if they do pass HR 1 or some aspects of HR 1 to try to make the democracy stronger, all of that will get challenged. There will not be anything significant that they include in democracy reform at the federal level that won't be taken up to the Supreme Court, and they'll be asked to say this is too much of an interference in states' rights, or it's this, or it's that. I don't think most of it is vulnerable of it to challenge, but that doesn't one of the things we learned in the last few years about the Supreme Court is you never know what, suddenly new rules appear. There's Shelby County, there's the ACA case that somehow the health insurance isn't in the Commerce Clause. I mean, it's just hard to be 100% confident that what this court might do.
Okay, so we are getting very close to the end of our time together. I am quite grateful to all of you for a wonderful discussion and a thoughtful set of insights that all of you shared with the audience. I think our kind of last pitch to all of you is, in 30 to 60 seconds, do you have a key lesson, a hope for the future, something that you would want us to take with us after this program?
I think my takeaway is, we sort of dodged a bullet with this election. And I certainly don't feel more confident in our system after this. I think this showed us a lot of weaknesses. And what we need to do is really work on addressing those weaknesses. Now, I would love to get rid of the Electoral College. There was a question in the Q&A I saw about the National Popular Vote Compact, which I think is promising. The other really important thing, I think, is to reduce the amount of control that Congress has. This is something Paul was saying earlier. If you look at what could have happened with a really ruthless majority in both houses of Congress, if we'd had one party controlling both houses, it could have been much, much worse. So, I think this election has been a useful diagnostic because it's really shown us where the weaknesses are, and what we have to do now is figure out how to fix them.
That's the pitch I've been making for the last hour and 10 minutes, but it does seem to me that ultimately, while we can make some fixes in our rather clunky 18th century election system, the ultimate safeguard has to be to start restoring people's belief that America is a democratic country and that we all ought to care more about that than any one political outcome. That's a long way back, but it's heartening to see a few of the people in the Republican side of the aisle who are saying these things out loud and saying, we can't be the party that just exists to peddle lies and claims of illegitimacy which are invalid. And so, I would love to see us get back to a time when people just believe that majority ought to win. That would be a really useful change in the political culture, which is going to take a generation, but maybe we can do it.
I totally agree with all of that. I think, I think this election cycle has really shed light on the fact that we do need democracy reform. And in addition to democracy reform, we have to continue to fight voter suppressive laws in courts. I know that, a lot of courts have become more conservative as a result of the Trump presidency. But we have to continue to kind of meet voter suppressive laws where they are. And I think, turning to the courts is still going to be an important mechanism and tool that we use until we get some real democracy reform in place. So that would be my takeaway.
I'd like to associate myself with the comments of everybody who has spoken. I think that we did dodge a bullet, and I think I loved, I don't remember if Paul or Aria said it, but I think the single best thing for voter confidence in the system is voting. And that a lot of people who were very iffy on the project really came out kind of bolstered in their confidence that it matters. And a lot of organizations did a phenomenal job of pushing that message. And I think that's the salvation here. We haven't talked much about state Supreme Courts, and we haven't talked about, the state attorneys general who, there is democracy reform that is kind of beyond just HR 1 and beyond just federal court reform. So I think just generally we have to think about triangulating against the proposition that votes need to count, and that if you're going to suppress the vote, you're on the wrong side of history. And I also think for me, the thing to focus on, as I said, is not to be doing these things 3.5 years from now.
All of that is fair. So that concludes our program. Thank you so much to all 4 of you for your insights today. I think you guys are superheroes, and I'm really grateful for all the things you do to not only fight in the courts, but publish and record podcasts and go on TV and inform the public about what is happening. So a big debt of gratitude, I think, is owed to all of you. I hope you have a wonderful night, and that is the end of our program. Thanks.
Thanks.